It's in their rules, and I'm not going to circumvent their rules and give you special privileges outside of anyone else. I handle several hundred defendants a year, and I'm not going to give you special treatment because you find yourself in a situation that you think deserves special treatment. But I'm telling you, there's nothing that you've told me that justifies me making an exception for you. 90 days in jail was meant as a punishment, and that's what it is. So I'm not going to change the rules just for you. Case number 24CR42159, the State of Ohio versus Lakita Miller. Ms. Miller is before the court with her counsel, Mr. Madden, Mr. Harris, on behalf of the State of Ohio. Mr. Madden, you wish to be heard?
Yes, Your Honor. I don't mean to be just to the court to have this hearing before you after we spoke. One thing I did not possibly make clear back in chambers was she could have gone in right away had she known this was going to be the case. Put things off, believing that she was going to get work release, and so she changed everything for her family and her life and her husband. In addition to the fact that brought up that at the time she was working from home, the same type of job she has now, and that was at the time that you allowed her work release was the exact same situation she has. I know she would like to address the court, and I know her husband here, and I think he would like to also. And I'm sorry to take the court.
Oh, go ahead, Ms. Miller.
Good morning. Thank you for hearing me. I just want to acknowledge that, as you stated at the sentencing, the time needs to be served. I worked with probation. I provided them all the information that they required immediately after sentencing. They also had me meet with a representative from work release, a gentleman who specifically asked me what I did for work, what platform, was it in person or online. He went through all of the challenges that people who work remotely incur with work release because there's 3 sets of rules that they have to follow. And at no point was anyone indicating or stating specifically that someone working remotely would be ineligible for work release. I didn't find that out until days before I was scheduled to commit. And we reorganized our lives to be able to make things, put things in place for me to be able to serve the time and have work release. So to find this out with short notice and no recourse and try to do everything is really causing more damage for our family. We really want to just do what you ordered and put this behind us, and this really makes it difficult for us to do that. I still have a family that I have to take care of. I've paid the restitution for what I did, and I want to serve the days. I'm just asking you to please allow me to do that with the sentence that you originally ordered. I'm willing to do whatever verification is necessary. If that means they need to come and do visits to verify that I'm working, that's fine. I have nothing to hide. I've been forthcoming this whole time. I just really would like the court to please consider that you gave me this privilege to begin with at sentencing. I feel like revoking it now would just be cruel.
Well, actually, I'm not revoking it. It's very clearly stated in the rules that Community Corrections went over with you that the remote employment is not permitted, and they have specific reasons for that. I mean, you've not given me any reason that I should deviate from their rules on how they do things. I should not treat you specially. This 90 days in jail was meant to be a punishment. I was gracious enough to allow you work release, but if it doesn't comply with the terms and conditions of Community Corrections, I'm not going to make an exception for you because I don't see any reason. Is it a hardship on your family? I get that. Yeah, 90 days away from your family is a hardship. I get that. It's meant to be a hardship. There's a victim in this case that was, and again, you guys agreed on a number, and I'm not going to contest that, but I would guess that the victims think that there's probably much more at a loss. I don't know, but that's the impression that I've been given. But again, I'm not going to make an exception for you in this case. There's just no reason for it.
Respectfully, Your Honor, I'm not asking for special treatment.
Well, that's exactly what you're asking for. The rules of Community Corrections that you went over and signed was that they do not permit remote learning. They have their reasons. I can't afford to have a probation officer go to your house every day to make sure that you're actually working and sit there with you. It just doesn't work that way. They don't have the time to do that. So I'm not going to allow it.
I don't know what rules they said that I signed. They never provided that to me. I was never told that. My own probation officer.
Well, again, Mr. Officer Steele back down here, who is the head of Community Corrections, and I'm not going to argue with you, but he's been very clear with me as far as what their rules are, that it's written in the rules. Whether you signed it or not doesn't make any difference. It's in their rules, and I'm not going to circumvent their rules and give you special privileges outside of anyone else. I handle several hundred defendants a year, and I'm not going to give you special treatment because you find yourself in a situation that you think deserves special treatment. It's not going to happen. So that's my order, and there's nothing that you're going to say today that's going to change my mind. I understand, according to Mr. Madden, this was contemplated back at the time of sentencing. I delayed taking you into custody for some period of time, and it really had nothing to do with work, to do with you staying home with your family over the holidays, which you were given that opportunity. I'm sure that the victims in the case would have preferred to see you go into custody that day, but I gave you grace at that moment. So at this point in time, I'm not going to change the rules for you. It's not going to happen. Okay? Is there anything else, Mr. Madden?
No, thank you.
Mr. Miller, do you have something you want to tell me, sir?
Yes, sir. Sir, if you can just hear behind council table so the.
Several times you made mention of here.
Yeah.
I just want to note it for the record that the victims, after your sentencing, went forth and pursued her on a civil level. Probably you don't even know,
I don't.
but they called her job, made it known, because the only time she disclosed where she worked at was in here. That was the only time it was disclosed was during the sentencing. The victims went to her job where she was employed prior to picking up this new job and made sure that they reported what happened so that she would lose that employment to cause further damage. I just want to note it. Our family has been through we've complied, we've done everything you asked us to do. She was able, even though that happened, she was able to secure another form of employment. The first time you came in here with sentencing, it was my understanding that you met with probation and work release to make sure that remote work was be allowed.
I did not. I did not.
Okay, well, okay. I just wanted you to know.
Okay. I appreciate. I am not aware of any civil proceedings that were filed.
Well, not civil proceedings, sir. They simply called her job, reported what happened after they obtained the information in your courtroom. It wasn't the only time that information was disclosed was in your courtroom. The information had actually been provided to you privately by her lawyer to you, and then they took that information and prosecuted. It's okay.
Hey, look, folks. I'm not going to get into this. What people did outside of this courtroom. You know, there was a plea agreement that was made in this case. She entered a plea of guilty. She was found guilty. I sentenced her, and I'm pretty certain that my sentence was reasonable. That's what I believe. I'm sure that the victims, and I have not spoken to any of them, but I'm going to guess that they thought my sentence was too light. I'm going to guess. You guys think my sentence was too harsh. So, you know, I try to use all available information, and again, I've been involved in youth sports in the past. I was president of the Lebanon Youth Football League. I dealt with this type of thing before personally, and I think that the sentence was fair. So, you know, they think it was too lenient. You guys think it was too harsh. I'm not changing the sentence. I did grant work release. I was not aware that this remote thing, I was not aware of that until Mr. Madden's motion. That's when I became aware that it was an issue. But that is their rules, just like when the jail has rules. And again, community corrections works under me. I understand that.
Sure.
But they have much more experience in supervising people than I do. I've been on the bench for 9 years, but they do the day-to-day supervision, and they come up with these rules for a reason, because they know that in the past it has caused problems. So they have these rules, and I'm not going to circumvent those rules. Just like I would not go over there and tell Sheriff, I almost said Sheriff Sims, Sheriff Riley how to run his jail, because they have rules over there, and they have rules over there for a reason. So I'm gonna defer to their judgment on that. Ms. Miller, did you have something else you wanted to say?
I just feel like they could have been upfront and forthcoming with that information when I met with
Ma'am,
them.
again, I don't know, again, I did not bring, Mr. Steele came down this morning for the conference. I thought this was settled. I could go get Mr. Steele and bring him back down here, and he could put on the record exactly when all this happened, when this was presented to you and stuff like that. But the bottom line is, he says, it's in the rules, they don't allow it. And again, do I have the authority to order it done anyway? Absolutely. But I'm telling you, there's nothing that you've told me that justifies me making an exception for you. The 90 days in jail was meant as a punishment, and that's what it is. So I'm not going to change the rules just for you. Okay? Anything else?
Yeah.
All right, thank you all.
To me, it's just despicable that you would steal from a youth organization. I mean, it's, you know, the whole organization is set up to provide a benefit for the kids that are participating in the organization, and it's you know, it amazes me that someone would sink so low than to steal from children.
A Mason mom convicted of stealing more than $35,000 from booster clubs supporting some Mason City School District extracurricular activities. Brenda Ordonez joins us live after sitting down with Warren County Prosecutor David Fornshell, who shared even more details about how she did it. Brenda.
Yeah, Tricia, the $35,000 is just what prosecutors could prove without a reasonable doubt Lakita Miller stole. They believe the actual amount is much higher. They say a lack of financial records made it difficult to track and try the full extent of Miller's fraudulent activity. In 2024, Mason football boosters notified police of suspicious withdrawals from their funds totaling just over $6,000. They found the money was being used to pay off credit cards.
We were able to obviously track those all to Lakita Miller,
a 44-year-old Mason mom who had gotten the football boosters' banking information in 2021 when she helped organize a one-time fundraiser.
And that's really what was the springboard in terms of the other investigation.
Miller volunteered for several youth organizations, including the Mason Cheer Boosters, where she served as treasurer. Warren County Prosecutor David Fornshell confirmed she had children in both the football and cheer programs.
The cheer boosters then began to check their bank accounts and noticed that they were in a negative balance situation.
Fornshell says Miller made nearly $30,000 in unauthorized withdrawals from the cheer boosters account she was responsible for managing.
You don't have a complete set of financial records to be able to determine how much was actually stolen, but it's our belief that it was considerably more than that.
Part of that problem stems from Miller linking the account to Venmo, something Fornshell says he hasn't seen before.
Obviously, in a situation like this, you never as an organization want to have your organizational checking account linked to a Venmo because it makes it difficult, if not impossible, to figure out where that money is actually going.
Investigators were able to confirm Miller used stolen money at Louis Vuitton, arcades, Costco, and Verizon. She also used some of the money to pay for her daughter's cheer uniform and cheer camp registration.
Are you asking me if there were some red flags? I think there were some red flags, yeah.
While Fornshell declined to divulge more, he says thefts from booster clubs are not uncommon, noting factors like little oversight, sole reliance on volunteers, and giving one person complete control of the financials.
It's just a recipe for internal theft.
That's why Fornshell is pushing for these organizations to implement proper safeguards to catch people like Miller before it's too late.
How long would this have gone? Would she have ever been prosecuted? I don't know. It depends on how quickly it would have subsequently been discovered, what records still existed at the time, and whether we felt we could prove it beyond a reasonable doubt.
So we do know that the football booster clubs did recover the $6,000 stolen from them. We also know that Miller did make a commitment to pay back the $29,000 that was stolen from the cheer boosters club before her sentencing. Fornshell will be hosting a training next month available for booster clubs, nonprofits, community members, and volunteers to help learn what safeguards they can implement to help prevent things like this from happening. For now in Warren County, Brenda Ordonez, Fox 19 Now.